Welcome, good afternoon everyone, and welcome to ACS's first lesson in the series, What the Constitution Means and How to Interpret It. My name is Raj Vorslino. I'm co-president of the Yale ACS chapter. This lesson is going to cover the first chapter of Keeping the Faith with the Constitution by Goodwin Liu, Pamela S. Karlan, and Christopher H. Schroeder. Throughout the lesson, if you have any questions, please type them into the Q&A box in the lower left corner of your screen. If you're participating in this lesson for CLE hours, please follow the instructions in the lower right corner. If you encounter technical difficulties, please contact the webinar provider at 866-903-7521. Feel free to tweet the lesson using ACS's hashtag #ACSClass. Also, continue the conversation on ACS's Facebook discussion page and on Twitter. And now I present Pamela S. Karlan, a visiting professor of law at Yale Law School and the Kenneth and Harl Montgomery Professor of Public Interest Law at Stanford Law School. Welcome, Pam.
Thank you so much, Raj, for introducing me and for hosting me here at Yale. Thanks to ACS for an opportunity to talk to folks about Chapter 1 of Keeping Faith with the Constitution, a book that I co-wrote with Goodwin Liu, who is now Justice Goodwin Liu on the California Supreme Court, and Chris Schroeder, who's now Assistant Attorney General Chris Schroeder at the Office of Legal Policy at the United States Department of Justice. So as the only non-official co-author of the book, it's great to kick off our discussion today. Some of you may remember earlier this year in January that the House of Representatives opened its session by having different representatives read various passages in the Constitution. Now, some people thought this was hokey, and some people thought this was a cynical sort of Tea Party-inspired political ploy. And it may have been both of those in some ways, but also I actually found it tremendously inspiring. And the most inspiring part of it for me was when Representative John Lewis from Georgia, who was one of the leaders of the Selma to Montgomery March in 1965, that was a militating factor in the passage of the Voting Rights Act, the crown jewel of our second Reconstruction, when he got up and read the 13th Amendment to the Constitution. Because it reminds us of several critical things about the Constitution's vision and values and how to interpret the Constitution. It reminds us that our Constitution has changed over time. The 13th Amendment was not in the original Constitution. Instead, the original Constitution was blighted by its implicit and not all that veiled approval of slavery. It reminds us also that the Constitution and the meaning of the Constitution has been forged not just by changes in the words of the document, not just by judges, but by activists in the field. John Lewis, as a college student, not much older, indeed younger than many of you who are watching the lesson today, did more to determine what our Constitution means today than any legislator, than any judge has done. And so, moving forward, you too will have the opportunity to help forge the meaning of our Constitution in the 21st century. Today, I'm going to spend about 15 minutes talking about the Constitution's vision and values and how we lay out arguments about the Constitution in Chapter 1 of Keeping Faith. The starting point for understanding the text of the Constitution is to understand the backdrop against which the Constitution was written. And there are two critical principles that cut in somewhat different directions that explain that our Constitution is an attempt to reconcile two very different interests, critical principles about what a government should mean. The first of these is that the Constitution empowers the government to deal with the critical problems that Americans faced then and to enable Americans to deal with the critical problems that the founders knew would arise as the nation moved forward. So the Constitution empowers the government to deal with critical problems. It is a response to the fact that the prior document, the Articles of Confederation, left us with a government that was too weak and too fractured to deal with some of the central issues of the late 18th century. So the Constitution created branches of government that did not exist in the Articles of Confederation, the executive branch and the judicial branch. The executive branch to execute the laws that Congress passed and to take care that those laws be executed, and the judiciary to make sure that the constitutional values were enforced. The one thing is the Constitution is intended to empower the government. At the same time, of course, the founding generation was coming out of the War of Independence against Britain and the concern that government sometimes could oppress individuals. And so at the same time that the Constitution contains a number of provisions and a number of structures that are designed to empower the government to serve, it also contained a number of provisions, both in the original Constitution and in the Bill of Rights, whose ratification was essentially a condition required by many people in order to ratify the original Constitution, contains a series of constraints on government power. From the very beginning, in the preamble to the Constitution itself, the Constitution makes clear that it's a document framed by we the people. It's not a treaty between the states alone. It's a document that begins with the words, we the people. It is designed to establish justice, to ensure domestic tranquility, to provide for the common defense, to promote the general welfare, and to secure the blessings of liberty. Now, none of those terms is a narrow legal code of something like the tax code or the like. These are sweeping statements of the purposes behind the Constitution and the purposes for having the government that the Constitution creates. And it's important in reading the Constitution and in understanding what the Constitution commands, what the Constitution authorizes, and what the Constitution prohibits, that we keep these purposes of the Constitution always in mind. The Constitution is a document designed to ensure liberty, to promote equality, to provide opportunity, and to create a government that works. And interpretations of the Constitution that are not faithful to these fundamental principles are not persuasive. Part of what the book tries to do, and in future lessons you'll be talking about this with respect to particular problems that have arisen in particular constitutional phrases that have part of the purpose of the book is to show that the Constitution from its very beginning was understood as a flexible document, as a document into which meaning would be inserted over time by the shared experience, the lived experience of the American people. And it was not intended to be frozen into a particular vision that was shared only by the framers in 1789 or 1791, or indeed even in 1868. So let me say a little bit about the original Constitution. The original Constitution, as it was written in the 1780s and then amended by the Bill of Rights, so the Constitution as we understand it in the 18th century, was clearly a document designed to protect liberty. Not just because it contains specific liberties in the Constitution that are protected, the right to habeas corpus, or in the Bill of Rights, the protection against unreasonable searches or seizures by the government, the protection of free exercise of religion and like, but also through the structure of the Constitution. The separation of powers among the branches of the federal government was designed, as the Federalist Papers suggest, to allow the checking of ambitions by other ambitions, to make sure that no one branch of government would have enough power to oppress people and to take away their liberties. So there are both substantive liberty protections and structural protections in the original Constitution. In addition to that, the Constitution was intended to enable the creation of a national government that would be capable of dealing with the economic and national security issues of the time. In addition, the original Constitution contained within it a number of provisions that were designed to create more opportunity. So let me just take one that the book mentions very briefly, but that's worth talking about, which is eligibility for federal office in the United States. There are very few qualifications on who can serve as a congressman, or who can serve as a senator, or who can serve as a president. And the framers of the Constitution were aware that they didn't have property requirements or wealth requirements, or indeed even requirements with respect to sex or age written into the Constitution. They were aware that this meant that the holding of political office in the United States would be open in a way that had never been true in previous countries or under previous systems of government. So opportunity is also a critical aspect of the Constitution. They also provided for the amendment of the Constitution. And by using broad phrases, they provided opportunities for future generations to give their understanding of what free exercise of religion is, or what freedom of speech is, or when searches and seizures would be unreasonable and the like. And that was not accidental. When the framers wanted to use specific language, they did. So, for example, the Seventh Amendment talks about cases involving more than $20. The qualifications clauses talk about age using actual years. They don't say you have to be mature to be president. They say you have to be 35 years old. The District of Columbia clause, the seat of government clause, says the District of Columbia can't be more than 10 miles square. It was not accidental that the framers used broad language in some parts of the Constitution and narrow language in other parts of the Constitution. Now that original Constitution, for all that we can venerate many of the things in the framers' generation as reflecting tremendous wisdom, was an imperfect document. Indeed, it was a tragically flawed document that said nothing about dealing with the largest blight on American history, the problem of slavery. It took a civil war to eliminate slavery in the United States, and that civil war profoundly changed the nature of our constitutional understanding. Give just one example of this. Before the Civil War, when people talked about the United States, they used the plural. So if you look at old Supreme Court opinions, they'll say something like, during the period 1812 to 1814, the United States were at war with Great Britain. After the Civil War, people no longer use the plural when talking about the United States. Today we say the United States is at war in Iraq or is at war in Afghanistan. That's a profound structural change in the Constitution. There were amendments that came out of the Civil War that mark a profound change in the relationship between the federal government and the state governments, and in the powers of the state governments vis-a-vis their own people. And so when people tell you to look back to 1791 for an understanding of what our Constitution means today, you should respond by saying you can't look only at 1791. You can't only look at 1787 and 1789. You have to look at the Constitution as it has been filtered through the Reconstruction Amendments, which are quite properly called America's second founding. The 14th Amendment writes into the Constitution principles of liberty and equality that weren't in the original document. And so it profoundly changes our understanding of the Constitution going forward. But even those words are capacious enough that our understanding today of what liberty means, or our understanding today of what equality means, is not the same as it was for the generation of 1868 to 1870. So, just to take one example, the same people who wrote the Equal Protection Clause in Section 1 of the 14th Amendment also wrote into the Constitution implicit discrimination on the basis of sex in Section 2 of the 14th Amendment, which quite deliberately did not protect any voting rights for women, although it did protect the voting rights of newly freed slaves. Today, by contrast, we understand that the equality protected by the 14th Amendment protects against arbitrary and impermissible discrimination on the basis of gender. And we've come to make arguments about how the 14th Amendment protects against other forms of discrimination that the framers of that amendment did not write into it in specific terms. So arguments today about the rights of disabled people, arguments today about the rights of LGBT people, are valid forms of constitutional arguments based on the text and the principles of 1868 filtered through another century's worth of experience. Now, since the Reconstruction Amendments, the later amendments to the Constitution have not been as broad and as sweeping, but they reflect the fundamental principles of constitutional law that have been in our Constitution since the beginning. So we have consistently, over the course of the 20th century, expanded the right to vote, extending it to women, extending it to people who couldn't pay a poll tax, extending it in presidential elections to citizens in the District of Columbia, and extending it to 18 to 21-year-olds during the Vietnam War era. We've changed the nature of the government's taxing power by allowing an income tax. We've changed the nature of the government's power by putting term limits in on presidential power. All of these amendments, while they're narrower in scope than the sweeping scope of the Bill of Rights or the Reconstruction Amendment, reinforce the understanding that ours is a Constitution designed to enable the government to respond to pressing problems, and that it's a Constitution about opportunity and equality and dignity for all of our citizens. So when you sit down to interpret the Constitution, you should take into account the nature of the problems that led to its founding, the understanding of the people who framed the Constitution, that it was not just a lawyer's document, but it was a layman's contract, their understanding that times would change and that the Constitution was designed to respond to those changes, to protect people even as government changed, while also empowering government to deal with problems that they could not have foreseen. It's faithful to the text and principles of the Constitution to interpret the Constitution in this way. It's keeping faith with the Constitution rather than treating the Constitution as an antique document hermetically sealed in the National Archives and impervious to changes in understanding or changes in society. I think that gives you an overview of Chapter 1, and we now have time to discuss, for me to discuss with you, questions you may have about how to think about the Constitution, its vision, and its values. So let's pause here for questions.
Remember, if you have a question, just type it in the lower left box, and Professor Karlan will get a chance to read them and answer them.
Great. Now, I think there's a question coming in, but it's very hard to read the questions for me because they're very tiny type. So. Oh, okay, great.
I'm going to go ahead and start off with one question, and I'm curious a little bit. You talked about the amendment process, and I think it's, I think the founders were, obviously very interested in keeping this as a living document and open to changing it. Do you think they intended the amendment process to be as difficult as it has been? The fact that we've only had 27 amendments over the course of our nation's history, do you think that's what the founders intended? Or do you think that has kind of been used for political gain, or has been obstructed a lot during the last few centuries?
Well, I actually think it's somewhere in the middle, which is I don't think that they thought that the Constitution would be nearly as hard as as it's turned out to be to formally amend. That is, you have to realize they didn't live in a world in which there were 200-year-old constitutions. The U.S. Constitution right now is really one of the one or two oldest constitutions of any kind in the world. And I think they assumed it would be easier to have formal amendments than it turned out to be. That being said, I don't think that the reason it's turned out to be so difficult to have formal amendments to the Constitution is because there's been some kind of cynical political manipulation. I actually think part of what's happened is the language of the Constitution itself has turned out to be capacious enough to deal with various problems without having to have formal amendments. That is, when, for example, the Article 1 of the Constitution talks about the power of Congress to authorize military forces on land and on the sea, we've come to understand that that also means that we can have an air force without having to formally amend the Constitution to add the words "and in the air" or the like. Some of this is that the broad, capacious language has turned out to be responsive to new problems. I don't think it's that they assumed that there would be very few amendments and we would be sort of frozen like amber in the time of 1791. Raj, does that answer your question?
I think that does answer my question.
Yeah.
Let's go ahead and look at some of the others here.
Sure.
One moment, please.
Slightly problematic.
Is there anything you want to expand on while we're sort
Well,
of...
one of the things I can talk about here is that I think one of the major reasons we wrote the book is to deal with the fact that there are seemingly simplistic buzzword theories that conservatives and reactionaries have used in recent decades that I think leaves some liberals feeling as if they should be on the defensive about their interpretations of the Constitution. So often hear, for example, that we should stick to the original meaning of the Constitution, or we should be strict constructionists of the Constitution. And as we explain in other parts of the book, originalism is not a principled theory of the Constitution, at least not originalism as it gets applied by anybody. So, for example, take Justice Clarence Thomas, who's probably the most radical originalist on the Supreme Court today. When it comes to the rights of kids in public schools, Justice Thomas says, well, look back in 1791, and it turns out pupils in school were told they had no rights. Therefore, public school students today should have no rights. Well, that's one way of being an originalist and saying, let's do what they did in 1791. But if Justice Thomas were consistent, he would then recognize, for example, that in 1868, Congress thought you could have race-conscious remedial programs, things like the Freedmen's Bureau, special schools that were set up in the South for black children and the like. And yet Justice Thomas says, oh, the Equal Protection Clause should mean no government distinctions on the basis of race. Well, that's inconsistent. And all originalists are, at best, to use Justice Scalia's terms, faint-hearted originalists, and at worst, they're disingenuous, result-oriented, personal preference-driven originalists. When people talk about strict construction of the Constitution, it turns out that they construe some parts of the Constitution strictly and other parts not. My favorite example here is, if you read the 11th Amendment to the Constitution, it doesn't bar lawsuits by citizens against their own states for violations of federal law. It says a lawsuit by citizens of one state against another state. So if I live in Connecticut and I sue the state of Connecticut, the 11th Amendment doesn't say anything about that. And yet conservatives have, since the 1890s, read the 11th Amendment to bar those lawsuits too. Why? They say, well, you know, the 11th Amendment is about a broader principle, the principle of sovereign immunity. Well, if they're going to be loose constructionists with regard to the 11th Amendment, they don't offer any explanation of why they're going to be strict constructionists with regard to other parts of the Constitution. Part of what we try to do in the book is to show that the Constitution isn't supposed to be subject to strict construction or loose construction, original construction, or let's just make it all up to date construction. It's supposed to be subject to faithful construction of the words and the principles behind them. Yes. So now we can see longer questions.
Right, here's the question.
Super.
How does a liberal or a progressive rebut limited or time-frozen analysis offered by modern Tea Party or Republican folks?
Well, one way you can do that is to point out to them that they themselves are not taking that position across the board. That is, you can say to someone from the Tea Party, and I encourage you to have conversations with people of different views. You can say to somebody from the Tea Party who says, well, we should do exactly what they did in 1791, say to that person, okay, well, in 1791, the Fourth Amendment would only have protected you against the government coming onto your property and conducting a search. So do you think it's okay for the federal government to stand across the street from your house and use a thermal imaging device to find out whether you're taking a bath or a shower? Do you think it's okay for the federal government to use a parabolic microphone while standing on a public street to find out about the intimate conversations you're conducting in your house? And most likely they'll say no. They'd be outraged if they thought the government could stand across the street and do that. And you say, well, for that to constitute a search, we have to change what the understanding of the Fourth Amendment was, because the Fourth Amendment used to require the government actually to come onto your property. Today, even Justice Scalia, in an opinion for the Supreme Court, understands that the Fourth Amendment protects people and information and not just physical privacy. Do you think the Air Force is constitutional? Well, there was nothing in the original Constitution to authorize the Air Force. Do you think federal consumer protection laws that protect you against adulterated drugs are constitutional? Well, there was nothing in the original understanding that would have protected you there. And I think once you get people to understand that a lot of what they assume the Constitution means is not the original limited, what would they have done in 1791 understanding, you can then discuss, well, what do these principles actually mean for us today?
Well, I think that leads on to this next question, which is, do you think the framers intended significant changes in the Constitution to occur by amendment or simply by interpreting it differently?
I think they assumed both. That is, I think when the Constitution sets up ideas like the government's power to regulate commerce, they understood that commerce might change over time, that the economy would change over time. But one of the central reasons why the Articles of Confederation failed and why we wrote a new Constitution was to create the American equivalent, the North American equivalent of the EU, a common market among the states. And so as our understanding of the effects of things that go on in the world on cross-boundary, cross-border issues changes, I think they understood that the power of the government would grow correspondingly. I think they also thought that there would be amendments of the Constitution. Indeed, I'm not sure that the original framers of our Constitution even conceived of 300 years later the kinds of changes there could be, or the fact that we wouldn't have a totally new written Constitution by then. So I think they understood that the Constitution would be a practical document for solving practical problems that would change over time. The principles would remain the same, but their application and the issues to which they would respond would change.
We have a question. Somebody is wondering, can you talk a little bit about the interplay between the 14th and 11th Amendment?
Oh, sure. I've written a little bit about this. So one of the things about the Constitution is later amendments should change how we think about earlier ones. So the Supreme Court has in general said, and I think they're correct when they say this, that Congress's enforcement powers under the 14th Amendment, and indeed the 14th Amendment itself, profoundly changed the relationship between the federal government, the people, and the states. So that the 14th Amendment turns the federal government in some important ways into a guarantor of people's liberties against their states. The result of this is that Congress's power to enforce the 14th Amendment enables it to override the 11th Amendment's provision of sovereign immunity to the states in federal courts. Now, my own view is that the so-called diversity interpretation of the 11th Amendment was right to begin with. That is, the 11th Amendment was designed to protect states against state law claims being brought against them in federal court without their consent. But even if you take the broader view the Supreme Court has taken of the 11th Amendment, which is it's intended to protect state sovereign immunity more broadly, the 14th Amendment, and in particular the equal protection and due process clauses of the 14th Amendment, and the privileges and immunities clause as well, are intended to override states' autonomy. And so Congress's ability to enforce those provisions under Section 5 of the Constitution should override the state's sovereign immunity. What worries me about the Supreme Court when it's in its more states' rights way of looking at things is they seem to be inventing a new amendment that I've referred to as the 11th Amendment, an amendment in which the 11th Amendment seems to trump the 14th Amendment rather than the other way around. The 14th Amendment trumps the 11th Amendment.
Okay, we have time for one more question, and it is as follows. How does the Constitution define or understand the concept of justice?
Well, I think the Constitution doesn't define the concept of justice. I think what it does is twofold. It sets up institutions, in particular a federal court system that is protected, that's given judicial independence through things like the life tenure entitlement that federal judges have. It sets up an institution that's designed to do justice in individual cases. And I think the Constitution also has substantive provisions in it that are designed to protect justice. A number of the Bill of Rights provisions are designed to ensure justice. So, for example, the jury trial right is designed to make sure that the government has to, that decisions about whether people's liberty is going to be taken away, or decisions under the 7th Amendment about claims that are litigated in federal court are not going to be decided just by judges who are federal employees. They're going to be decided by the people. Protections against cruel and unusual punishment, the Equal Protection Clause. These are provisions that are designed to enable justice, but I don't think the Constitution by itself defines justice. What it does is it sets out mechanisms for ensuring that justice is done.
All right. Well, thank you so much for participating in this conference call, What the Constitution Means and How to Interpret It. Thank you very much to Professor Pam Karlan for a wonderful discussion. And for all of you listening, please make sure to keep this discussion going on Facebook, Twitter, just through conversations that you have. And we will be having many more of these discussions throughout the course of the semester. So thank you very much. Goodbye.
Bye.